Part of the community of practice is that we really want to engage our families, and we want to engage our stakeholders in a meaningful way. So how do we use the community practice to push forward initiatives that the DD Council has developed, or the Family Support Council is working towards? How do we all work towards the same goals, engaging our family members as well as our systems? And so one of the things that keeps coming up time and time again is the question of guardianship and alternatives to guardianship. We get contacted at the state from the division quite often from families as well as stakeholders, whether it's community support providers or educators, wanting to give families more meaningful information about what their options are. And so as we were discussing, like, the amount of phone calls and questions we get, and even community support providers are providing participant rights under guardianship, it just poses a lot of good conversation, poses a lot of questions that are maybe sometimes unanswered, or we don't know where to find that information. And so as a community of practice, we're going to talk today a little bit about what guardianship is, what the alternatives in South Dakota are for viable options, and then how do we, or what do we need to do to move forward, allowing families to make an informed decision about guardianship and alternatives. So we thought we would just start out with just kind of breaking down what some of those alternatives are. We're going to start with the less restrictive and move towards the most restrictive, which is guardianship, in the purpose of just really so we're all on the same page of what we're even talking about. And then we're going to have some great discussion and some breakouts later on where we see areas of need, ideas of how to meet those needs, and how as a community of practice we can move those forward. So we'll just start with the next slide, which is supported decision, transfer of rights. Transfer of rights, we'll start way back in the beginning. So transfer of rights, what does that mean at the age of 18? So transfer of rights is essentially anybody under the age of 18 has a guardian, a parent or guardian that makes substitute decision making for them until they reach the age of 18. When they reach the age of 18, those rights or decision making abilities get transferred over to the 18-year-old. That's the all. When we talk about the all, that happens in everybody's life. Now, what does that mean for aging adults? Sometimes aging adults, they've had the ability to make decisions for themselves and have had capacity to make decisions for themselves, but then they enter a time in their life where maybe dementia or Alzheimer's, or there's some type of medical need that develops a need for intervention on supported decision making or substitute decision making. Our state calls it substitute decision making in a lot of the admin rules, and but it's all of it. It's substitute decision making and supported decision making. So the concept behind it is you're making those decisions in support of that individual. So whether or not they're turning 18 and they need substitute decision making because they lack capacity to make decisions for themselves, or they've had capacity their whole life to make decisions, but then they enter into a stage of life where they're no longer able to make those decisions. How do we know when a person's reached that point? And then how do we know what the options are to intervene for those substitute decision making abilities? For an 18-year-old, as we all know, I have a 19 and 20-year-old that sometimes I question their decision-making abilities, but they are of age, the rights have been transferred, and so I have to allow them to have that dignity of risk. And so we don't want to change necessarily that just automatically for somebody with a disability. What we really want to do is understand what are the areas that need to be substituted for decision-making, and how best to go about supporting them in their decision-making abilities. Could it be a guardianship? Absolutely. There are a lot of individuals that need full replacement or substitution of decision-making, whereas there's other individuals might need just support in decision-making. And what does that look like for legal interventions? So how do I know which option is best? We'll get to that, but let's talk about the options to start with. Supported decision-making. It's a fancy name for what we all do every day. We ask people we trust for help in making decisions. Sometimes it seems easier to just decide for someone, but by allowing them to make their own decision and mistakes, we teach self-determination and allow for growth. And a lot of states, our state is not one of them currently, but there are several states where supported decision-making is actually a legal intervention. It's written in their state laws as a way to support somebody with a disability who might need that supported decision-making, and there's a contract that is notarized and is considered a legal agreement where that individual, much like an IEP team or an ISP team, where they come together and the person selects the individuals. It could be an aunt that's really good at finances that helps them make financial decisions. It could be a former teacher that just has mentored them their whole life and they really want that person on their team. It could be somebody that's helping them make decisions about supports, whether they services and supports, whether or not they would enroll in a program that's offered by the state or a waiver service. And so the person develops their team and the team agrees on how often to meet. And it's basically your social network and your safety net and your expanded natural supports that help you make decisions in all the different areas of your life. So that's what supported decision making is. We all use it. When I went to buy my first car, I certainly brought my dad along to help. I didn't necessarily allow him to make the decision for me, but I certainly valued his input on whether or not he thought it was a good purchase to make. So supported decision making is a legal intervention in some states. In our state, it's just a way of life and a practice. Next slide. Then we have power of attorney. So power of attorney is still a legal intervention for substitute decision making. It gives somebody the ability to feel a little bit of peace of mind that they're, when somebody maybe is capacitated to make a decision, but would lose capacitation, so becomes incapacitated. Maybe they have a lot of medical needs that are hospitalizations are common, or financial power of attorney. There's certain times where they are able, we see this a lot of times with individuals with mental health diagnoses, where sometimes in their cycle of their mental health, they're competent to make decisions, but then there's other times where they lose that capacity or competency to make decisions. And so you'll see that power of attorney come into play, because we don't want to necessarily take away all decision-making ability, but we certainly want to make sure that there's certain safeguards in place if there needs to be a legal intervention. So it was commonly used in business and estate planning practices. One competent person, which is the principal, gives another, the attorney in fact, the right to act on their behalf in certain situations. So for an example, way back in the day when this was developed, say I had somebody I had my own company and I had somebody that worked for me, and I was sending them to a business meeting to make decisions on behalf of the business. I would give them power of attorney to make those decisions, those business decisions on behalf of the company. So that's essentially how it began, and now it's used in common practice for day-to-day life. So healthcare decisions, you just provide a copy to the providers, and then financial management like banking, bills, cell phone plans, because honestly, unless you're on that person's cell phone plan, I don't know if you've ever tried to go and make changes, but unless you're on that cell phone plan, you're not able to make those decisions. So what happens if the person that you are supporting in decision making becomes incapacitated? Now, how do you pay those bills or even find out how much is owed on the bills? So that would be a legal intervention. It doesn't have to go through the court system. It just has to be signed and notarized, witnessing the signatures that both are in agreement. Now, I have to disclose I'm not an attorney. I can't give out any legal advice. This is only just informational so that you understand that there are different options for legal intervention. It's always a good idea to make sure that you're consulting with an attorney if you have any questions on which legal intervention would be appropriate for you. Next slide. All right, next one is limited guardianship and conservatorship. We're actually seeing this a lot more in South Dakota. I think judges and attorneys are really kind of have a better understanding of people with disabilities, and also see, you know, the aging population where they might still be able to make some decisions for themselves. So what specifically do they need substitute decision making, and can we limit the guardianship to just those areas? So a limited guardianship avoids a guardian that is overly too broad and restricts the rights of individuals that really are capable of exercising fully to some degree. It can be expressed limited in time or in scope. So you can ask the court order to be protected for only what's needed. So for an example, maybe an individual is turning 18 and, you know, they're still in the education system, and the families are worried about, you know, not being invited to an IEP, or that individual signing themselves off of their IEP, or that you're trying to initiate services for an individual that has his own guardianship, but they don't necessarily want those services, but you know that those services are needed. You can be very specific on what supported decision making, what guardianship, what are the substitute areas that need to be decided for a person that doesn't necessarily take out all of their rights. So let's say, and this has happened lots of times, where somebody turns 18 and they're just not quite at the place where they're ready for making all of their decisions. You know, there's a lot of growth that needs to happen, maturity. And so you can ask the courts to give you limited guardianship, maybe from 18 to 25, just to cover that time frame, so that you're encouraging and continuing those services and supports, but that would be expired at that point. And then you could certainly petition the court and ask for that to be extended if it's necessary. So that's where we talk about limited in time or in scope. I want to have conservatorship for the duration of their life, because they really don't understand money. Conservatorship is the substitute decision making for financial. So maybe they're always going to need financial intervention, just because that's not a skill set that they carry, and most likely will continue through their adult life. However, you are confident that eventually they'd be able to make decisions on where they want to live and where they want to work, and what type of relationships they have. And so you might do limited guardianship for a time frame, and then the scope would continue on with conservatorship. The protected person retains all rights and they have not been granted to the guardian. So it's really important too, if you do see guardianship papers come across, to look to see what the court did specifically order, because just because a family member says, I have guardianship of my adult child, look at that guardianship paperwork, because it might have just a scope of what they're making decisions over. Next slide. And then we have full guardianship. We just know that individual lacks the capacity to make decisions. We are still going to offer supported decision making even through our guardianship. Just because you're taking over full guardianship and you have the final say over things, it doesn't necessarily mean that you have to, if you obtain full guardianship. You want to be inclusive. You want to be supported in those decisions, just like anybody would want to have somebody come alongside them and help them make a decision together. The guardianship would, in fact, though, allow you to have kind of the final say. It prevents transfer of rights if completed before the 18th birthday, and it's traditionally a default option, also the most restrictive. So when children are leaving the education system, or going through those transition plans into adulthood, it is required that guardianship is discussed. But not very often do we see alternatives to guardianship. We're getting better at it. I think we're getting good information out there. But right now we just don't know what we don't know, right? So if there's not a lot of good information out there on alternatives, and even like, how do I even decide what the best option is, then we can't fault anybody for not providing that information if we don't know what the information is. And so I hope this conversation today will lead us into more ideas and generating thoughts and processes and sharing experiences of what the need is for families, and how do we get that that need met. So guardians make decisions about everyday life, healthcare, food, living, associations, work, everything. Conservators make decisions about finances and how they spend their money, property, all that good stuff. So